My name is Kucklick. I'm the president of the Administrative Court in Dresden, the capital city of Saxony. In total, Germany has 16 provinces with 16 judicial districts, so to speak. And in those 16 jurisdictions, we have various procedures. In our administrative court in Dresden, at the end of March, we had 69 employees, 36 judges working in 14 departments, and 33 additional auxiliary staff. In 2011, we began in our court to introduce electronic filing system, but it should not be mixed with electronic communication as such. It's also about processing of various cases. It's just secondary e-files, so to speak. In the first 3 months of 2017, we received over 3,500 cases, which then had to be dealt with, processed individually. And in total, now it's 6,500 cases. I've mentioned that we have this software called VGFG, used not only in Dresden, but also in two other administrative courts in Chemnitz and Leipzig, and also in our Supreme Administrative Court in Bautzen. What is unique about Dresden is that we combine these specialist proceedings with document management system, hence this abbreviation VGFG, and we use this system to manage document flow in order for all paper documents we use to be also digitized and available in electronic form. Electronic document handling was introduced in Saxony many years ago, which means that the administrative court in Dresden is available to everyone, not only to lawyers, through the electronic inbox. And since last year, we've had a special electronic inbox for attorneys. Dr. Munz yesterday talked about this electronic inbox for attorneys. Very few lawyers use this now, this special inbox for attorneys. We can count them on the fingers of one hand. Last week, I found out that 4 law firms communicated with the administrative court using this special electronic inbox. The system is used, system EDFP is used more widely, but it's just 36, 37 barristers using electronic communications. In other cases, probably in your case as well, the entire mail is in paper format. Then in our law firm, the documents are scanned by our staff. In order for the documents to be processed further, they have to be scanned, and then also we have to add metadata or tags. I hope that after some time, documents will no longer be sent in paper format, but lawyers, as of 2022 at the latest, will present all the documents in electronic form and will provide the court with well-structured data. As I've said, this will happen from 2022 onwards. However, already at this point, we have electronic mail available. We have incoming letters, and this is related to the Federal Immigration and Refugee Authority. The number of asylum cases processed by the court has increased, so the Federal Immigration and Refugee Authority sends the entire correspondence to us electronically. This means that we are dealing with a large number of messages, of incoming messages. In this way, attributing correspondence and files to our secondary electronic files facilitates this process. We don't use electronic files only to turn them into main files. I will speak about that later. At the moment, it takes quite a lot of work to transform the files, the documents, into electronic form, and it's not our objective yet. If we have paper correspondence available, some of our departments, in each department we have at least 3 judges cooperating with each other, and those departments have decided to process incoming mail in electronic form. That is why our service departments have create those electronic folders, who, when, has to take which steps. Also, correspondence between judges, and it ends up in our service unit where the entire outgoing correspondence is processed. So inside our court, all the documents flow electronically, are sent to people that will deal with them. At the same time, we've done something we didn't have before in administrative court. We've come up with so-called smart or intelligent forms. So if a judge wants to issue a decision or say, request a few copies of some letters to be sent to the opposite party, he or she fills in a form, electronic form, which is sent electronically to the service unit, and the service unit prints out just by clicking on one button, and all the forms are processed automatically. Of course, this is a great help for the service unit, which now does not have to apply to various judges to look for the various letters, and this greatly facilitates their work. Now the judges, when they have at their disposal the entire contents of a file, can process the documents, administrative documents. They can copy some phrases and use them in their own decisions. They don't have to dictate that. They don't have to have them transcribed. They can also mark some fragments in color. They can introduce their own remarks or notes they only can read. So this greatly facilitates their work. This is, of course, in a trial period yet. It doesn't require a lot of work. The judges have 27-inch screens, so this is not a great change, but we are looking with envy at the Bavarians. For instance, in Landshut, maintaining electronic files and processing those files is being tested at the moment, and in Bavaria we have different monitors and notebooks which make it possible to record the files and take them home. We as judges often have sessions outside our court, and we can take such files in electronic format. taking our notebooks with us. We haven't arrived there yet. We haven't been able to persuade our authorities, but I can see that our president, the president of the highest administrative court, is listening to what I'm saying and will back our request, I hope. We've heard about data security, and yesterday you probably heard a lot about this. In our case, we have all the data on the server, and we are the only entities with access to these data. We have a server, the documents are on the server. Several judges have tokens by means of which they can have access to the files at home. They can bypass, in a way, the firewall, which provides security for these files. The judges don't have yet, however, electronic signatures. They are unable to sign their verdicts, decisions electronically. We still have this deficit. If a decision is to be issued by a judge, it is issued in a traditional format, and then it's added to the electronic secondary files. After we've processed a case at court, we send out correspondence. As I've said, very few lawyers have decided to switch to electronic communication with us, which means that we can send very few letters by email. So we send them correspondence by fax, computer fax. So this is the entire correspondence, not requiring signature. 90% of our correspondence in our court doesn't. If we don't have the special electronic inbox, we use computer fax to communicate with lawyers. Also, service units, in our case, use our procedure, VGFG, and then tools they have, they can control computer fax. So we do not print out our correspondence, we just print a button and it sends it electronically. What it means for our employees, they don't have to copy the documents or make a lot of copies of letters. We have about 2,200 outgoing messages like that, but only 50 get to this special electronic inbox for lawyers. So it's just about 10% only of 10% of the whole correspondence. Still, a vast majority of correspondence is carried out in paper format. We have a problem because computer fax is limited in our case, so we can send only documents that the size of which is 30 megabytes. Files from the Federal Immigration Authority are bigger, 100 megabytes at least, which means that in each case, in each individual case, our service units have to divide such files into 3-4 parts, and then we can send them, which of course costs a lot of work, is labor intensive, and I hope this will change in the future. When it comes to a description of this procedure, we can see straight away that work with electronic files hasn't led to a vast improvement or greatly facilitated our work, or has brought about a great change. So electronic files are not made available when lawyers call us. No, let me put it differently. Lawyers call us, the service unit may immediately provide them with information about the status of a case. So it's about bringing about a situation where no one wants to go back to paper files. we also have this possibility of taking the files with us to some sessions or home, and judges think that this has great advantages. What we have to improve is the number of messages, incoming and outgoing messages. What we also have to change is the lawyers' attitude and encourage them somehow to use us, to send us structured metadata that are the subject of an agreement in our federation. So not just every province, every land has its own data system, but it's made uniform on the federal level, which makes it possible to exchange data not only between lawyers and courts, but also between various courts, various instances. So if I want to send some files from Saxony to Lower Saxony, they should be readable by means of the same set of data. It makes sense then. At the moment, we are also dealing with another issue. We want to introduce an electronic communication platform in Saxony. It should be uniform, not only for the justice system, but it should also serve other departments, like in government, in justice. We've heard about that a lot today. The whole thing is going on quite well. What is problematic still for us is that in our court in Dresden, we don't have a specialist, an IT specialist. This is associated with the fact that the justice system in Saxony has decided to have this entire expertise in one unit specifically for Saxony. As a result of which, we need to discuss various problems in this major unit. It's not just we have interpreters like Polish, German, and Polish English interpreters. The justice system, too, when it comes to IT Justiz, that's the name of the system. If this department gets electronic mails, they don't understand this. So they have problems, and you have to interpret or translate that for them. Our administrative court in Dresden is the first court that has decided to try to test electronic files. In Germany, to make such files, primary files, is still a long way ahead. The Saxonian Minister of Justice, towards the end of last year, signed a cooperation agreement with Baden-Württemberg, with Thüringen, with Schleswig-Holstein. And it's about coming to some kind of agreement on e-filing systems. There is also a project in Bavaria, and in Bavarian courts by 2018, they want to introduce electronic files as primary files. I don't know whether they will be able to succeed. 6 Länder have concluded this agreement in order to use e-files in courts as E2 files. In Saxony, in our case, the question of when such files, such documents will be primary files is hard to answer. Neither Mr. Künstler nor I can answer this question unequivocally, but already now we are getting some experience in that, and I think that this will lead to the expected results in the future. Thank you very much.